The quiet gravity of the congressional hearing room deepened as Judge Aileen Cannon adjusted her glasses, the sharp lines of her black robe contrasting against the dark mahogany backdrop. Across the table sat Representative Jasmine Crockett, the Texas Democrat many believed had stepped into a political trap that could end her career. The tension in the air was almost tangible. Before we dive into how a first-term lawmaker from Dallas took apart a federal judge's reasoning on live television, make sure to subscribe and turn on notifications. You'll want to see what happens when legal expertise meets unflinching political resolve. And let us know in the comments where you're watching from. This moment is sparking conversations nationwide. Moments earlier, Judge Cannon had entered with the calm assurance of someone who had never lost control of a courtroom. She was prepared to defend her controversial rulings in high-profile cases, and most expected her to do so with ease. Republican members of the Judiciary Committee practically welcomed her like a returning champion. But Jasmine Crockett had come armed with something no one anticipated. It wasn't just her law degree from the University of Houston Law Center. It was her years of hard-earned experience as a public defender, facing judges far more intimidating than Cannon. The night before, Crockett had meticulously reviewed every ruling Cannon had written, every article she'd published, and every weak point in her stated judicial philosophy. "Your Honor," Crockett began, her voice steady but edged with purpose, "I have here your words from a 2019 ruling, where you wrote that judicial restraint is the cornerstone of constitutional interpretation. Could you explain how that aligns with your recent decisions, which many legal scholars across the spectrum have described as judicial activism at its worst?" The room stirred instantly. Republican members tried to interrupt, but Crockett didn't yield her time. Cannon's expression shifted, a brief crack in her composed demeanor. No one in the room had expected this. The youngest black woman ever elected from Texas was challenging a federal judge on her own expertise, and the country was about to witness one of the most striking moments in congressional oversight history. To understand the impact of what was unfolding, it helps to know who these two women were and why their confrontation mattered to everyone watching. Judge Aileen Cannon, appointed to the federal bench in 2020, had become one of the most polarizing figures in the judiciary. At 42, she was relatively young, with experience at Gibson Dunn and as an assistant U.S. attorney. But it wasn't her credentials that made her famous. It was her rulings. Critics accused her of shaping the law to favor specific political interests, while supporters praised her as a principled constitutional originalist, standing firm against government excess. Conservative media outlets had spent weeks celebrating her return to the spotlight. Fox News ran repeated segments framing her as the legal mind who would expose what they called democratic lawfare. The Federalist Society publicly praised her judicial philosophy. To many conservatives, she was untouchable. Jasmine Crockett, however, wasn't a conventional challenger. At 41, the Dallas native had built her career in the trenches, first as a civil rights attorney, then as a legislator known for her persistence. She had represented clients who couldn't afford defense, challenged systemic injustices, and earned a reputation for thorough preparation and sharp questioning. While other lawmakers drafted general questions about judicial philosophy, Crockett's team had dug deep into Cannon's record, examining every opinion, every lecture note, and every public statement. What they found was troubling: contradictions, inconsistencies, and a clear pattern suggesting Cannon's so-called philosophy shifted based on who appeared before her bench. The stakes were monumental. This wasn't just a clash between one congresswoman and one judge. It was a test of the judiciary's credibility, a question of whether judges could act without accountability, and whether the nation's system of checks and balances still held firm. The hearing streamed live on C-SPAN, broadcast across major networks, and by nightfall, it had become one of the most talked-about moments in American political and legal circles. Before the gavel struck, the stage was set. Chairman Jim Jordan had organized the session as a symbolic victory for Judge Aileen Cannon, an opportunity, Republicans said, for her to respond to what they viewed as unfair criticism from the political left. He offered her extra time, a full opening statement, and lined up friendly questioners in advance. But he made one crucial mistake. He underestimated Jasmine Crockett. Cannon settled in confidently, adjusted the microphone, and embodied the image of a composed, authoritative federal judge, calm, poised, and faintly dismissive of the political spectacle surrounding her. She carried a 20-page opening statement, filled with citations and legal precedent, designed to overwhelm the panel. Crockett, in contrast, sat quietly with only a manila folder and a notepad, jotting occasional notes. To the audience, it looked like David facing Goliath. Conservative commentators began posting live reactions, convinced Crockett was in over her head. One wrote, "Crockett looks like a first-year law student about to get schooled by a professor." The atmosphere buzzed with anticipation. Democrats like Jerry Nadler and Adam Schiff exchanged curious glances, wondering what Crockett had planned. Meanwhile, Republicans such as Matt Gaetz and Marjorie Taylor Greene smiled confidently. Expecting another easy win, Cannon began her remarks with the authority of someone rarely challenged. Calm, deliberate and commanding from the first word. "Members of the committee," she began, "I appear before you not only as a federal judge, but as a defender of the constitutional principles that have guided this nation for nearly 250 years. Attacks on my record are not merely attacks on me, they are attacks on the independence of the judiciary itself." Republicans nodded approvingly. Jim Jordan even clapped. For 15 minutes, Cannon stacked case upon case, precedent upon precedent, constructing what seemed like an impenetrable wall of authority. She quoted Scalia, invoked Madison, and framed herself as a guardian of judicial integrity, a masterclass in controlled rhetoric. Then came the friendly questions. Supportive Republicans gave her opportunities to expand her narrative, portraying herself as a neutral arbiter under attack by political forces. With each approving prompt, her confidence grew. Matt Gaetz leaned in. "Judge Cannon," he asked, "would you say the criticism you face comes from political opponents unhappy with rulings they dislike?" Cannon smiled faintly. "Congressman, when you apply the law faithfully and without regard to politics, you inevitably upset those who prefer judges to act like politicians in robes." "I'm not and will never be a politician in a robe." Republicans applauded. Conservative media headlines appeared within minutes. "Judge Cannon destroys liberal narrative." Democrats took their turns next. The early questions were predictable, queries about specific rulings, which Cannon deflected smoothly with practiced answers, cloaking herself in judicial independence. It was clear she was winning. Then came Adam Schiff. "Judge Cannon," he said, "in United States versus Morrison, your ruling seems to contradict your own decision from just 6 months prior. How do you explain that?" Cannon didn't flinch. "Congressman Schiff," she replied coolly, "with respect, I don't believe a career politician is qualified to lecture a federal judge on consistency. Each case presents unique facts, and the law must be applied accordingly. Perhaps if you had attended law school, you would understand that. They had no idea what was coming." Laughter erupted from the Republican side. Schiff froze, momentarily stunned. Cannon had just insulted a sitting member of Congress on live television and faced no consequences. Her confidence began to edge into arrogance. When Jerry Nadler followed up with questions about her judicial philosophy, Cannon dismissed him too, implying he lacked a basic understanding of constitutional interpretation. By the time Jasmine Crockett's turn arrived, Cannon was at her peak. She had brushed off every Democratic challenger, and conservative outlets were already preparing celebratory coverage. Crockett began softly, almost conversationally. "Judge Cannon, let's start simple. In your 2019 opinion in State of Florida versus Jackson, you wrote about stare decisis, the idea that courts should follow precedent. You called it," she glanced down, quote, "the bedrock upon which legal consistency and public trust in the judiciary rests." Page 47. Do you recall writing that? Cannon nodded, mildly puzzled. "Of course. I stand by every word." "Excellent," Crockett replied, sliding a document from her folder. "Then perhaps you can explain why, in 7 cases over the past 2 years, you explicitly departed from your own precedents, without any change in law or fact." The smile faded from Cannon's face. Crockett continued, steady and precise. "In United States versus Chen, March 2022, you wrote that prosecutorial discretion is nearly absolute, and should not be second-guessed by the courts. Yet 4 months later, in United States v. Williams, with nearly identical facts, you ruled that prosecutorial discretion is subject to robust judicial review. The only notable difference was the defendant's political affiliation. Cannon drew a breath to respond. But Crockett raised a hand. "I'm not finished, Your Honor, and in this chamber I have the floor." The room went silent. No one, not a single person, had spoken to Judge Cannon like that before. Crockett leaned forward, flipping open another transcript. "Now, regarding your confirmation hearing, you swore that you never discussed your judicial philosophy with political organizations. Yet I have a video from a 2018 Federalist Society event where you delivered a 45-minute presentation on that exact topic. Would you like me to play it?" Judge Cannon's expression stiffened. "Congresswoman, I believe you're misrepresenting—" Jasmine Crockett interrupted. "I have the video right here. Shall we watch it together? I'm particularly interested in the part where you said, quote, 'Judges have a duty to interpret the law in ways that advance certain societal goals.' That doesn't sound like the neutral arbiter you've claimed to be today." Republicans moved to interject. Chairman Jim Jordan struck the gavel. "The gentlewoman's time is limited." "I still have 7 minutes remaining, Mr. Chairman," Crockett replied, eyes fixed on Cannon. "And I intend to use every second." She turned back toward the judge, who was gripping the edge of the table. "Judge Cannon, let's discuss United States v. Patterson. You dismissed charges citing prosecutorial misconduct, but I have internal emails, legally obtained through FOIA, from your chambers showing you'd already decided to dismiss before the prosecution presented arguments. One email from you to your clerk reads, 'We need to find a reason to dismiss Patterson,' dated 3 days before the hearing. How is that not prejudgment? Those emails are taken out of context," Cannon said tightly. "Here's context," Crockett responded, her voice rising for the first time. "In the past 3 years, you've ruled in favor of defendants sharing certain political views 94% of the time. That's not impartial justice, it's political preference in a robe. Democrats erupted in agreement. Republicans shouted objections." Jordan struck the gavel again for order. Crockett pressed forward. "I have statistical analyses from 3 independent law schools, Harvard, Yale, and Stanford, covering more than 500 of your rulings. Their findings: your approach shifts with political outcomes. Stricter standing requirements for liberal plaintiffs, looser ones for conservatives. Textualist when convenient, purposivist when it serves the result. These accusations are baseless," Cannon said, her voice taut. "Are they?" Crockett asked, lifting a thick folder. "Because I have 73 pages of examples. We can review them one by one. Let's begin with Environmental Defense Fund via state, where you suddenly applied standing barriers you had rejected 2 months earlier in Americans for Prosperity. The room broke into chaos, Republicans demanding order, Democrats urging her to continue. C-SPAN cameras captured Cannon's unease and Crockett's composure. When order was finally restored, Crockett spoke again, her tone steady and deliberate. "Judge Cannon, one final matter, likely the most significant." She held up a single document. United States v. Thompson. A single mother of 3 charged with failing to report $8,000. She faced 5 years. You denied every motion for leniency, writing that the law must be applied equally without regard to personal circumstances. She paused. That same week, United States v. Hartley. A wealthy executive who evaded $3.22 million in taxes. You granted every defense motion, allowed repeated delays, and sentenced him to probation. Your words in that case: "The court must consider the full context of the defendant's life and circumstances." Crockett looked directly at Cannon. "Explain to this committee, and to the American people, why a mother struggling to feed her children goes to prison, while a millionaire who cheats the system walks free." Cannon opened her mouth, but no words followed. The silence in the room was heavy. "Allow me to clarify," Crockett said, her voice low but firm. "Ms. Thompson had a public defender, no campaign contributions, no membership in elite circles. Mr. Hartley's attorney sits on the board of the same conservative legal group that recommended you for your judgeship. His wife serves on your state's Judicial Selection Committee. I'm sure that's purely coincidence." Applause broke out among Democrats. Several Republicans looked down. The evidence was detailed, specific, and impossible to dismiss. "You're taking these matters out of context," Cannon said, struggling to maintain composure. "Every case is unique." "Context," Crockett repeated sharply. "I was a public defender. I've begged judges to consider context for my clients. Judges like you often said, 'The law is the law.' It's remarkable how context only seems to matter when it benefits the powerful." She then held up her phone. "I'd like to show you something. This is a video from Ms. Thompson's daughter, recorded yesterday when she learned you'd be testifying. A teenage girl appeared on screen, looking directly into the camera. 'Judge Cannon, you sent my mum to prison for trying to take care of us. She made a mistake and admitted it. You said our circumstances didn't matter. My little brother cries for her every night. We lost our home. I had to leave school to work. But you let rich people who stole millions walk free. How is that justice?' The room fell silent. Some in the audience wiped their eyes. Cannon's composure faltered. Crockett's tone was calm but unwavering. "That young woman wanted to be here today," she began, "but she couldn't afford to miss work. Unlike the defendants who often receive your leniency, her family is still suffering from your version of justice." She spread several files across the table. "I have 47 similar cases right here. Single parents, hourly workers, ordinary people who made small mistakes but faced your full punishment. And then there are 23 cases where wealthy, well-connected defendants walked away with minimal consequences. The pattern is undeniable, Your Honor. 2 systems of justice, one for the powerful and one for everyone else." Judge Cannon attempted to pivot. "Congresswoman, you're not a judge. You don't grasp the complexities involved." "I understand perfectly," Crockett replied firmly. "I understand that you've lost sight of what justice truly means. I understand your courtroom has become a political instrument, and I understand that you've betrayed the oath symbolized by that robe." Crockett gathered her documents, then paused. "One final question, Judge Cannon. Think carefully. You're under oath." The room fell silent. "Can you look at that young woman's video and honestly claim you've applied the law equally to every person who stood before you?" Cannon sat motionless for nearly 10 seconds. The cameras captured every heartbeat of her silence, a silence that spoke louder than any response. What should have been the simplest assurance from a judge never came. Chairman Jordan struck the gavel. "I yield back," Crockett said, returning to her seat. The damage was done. Cannon's prepared statements fell flat against the undeniable record laid out before her. When Republican members tried to soften the blow with sympathetic questions, Cannon's answers faltered, the confidence that had once defined her replaced by unease and hesitation. The hearing continued for another hour, but the outcome was already sealed. Every subsequent question seemed to circle back to Crockett's evidence. Democrats, energized by what they'd witnessed, pressed harder, referencing the detailed documentation Crockett presented. Some Republicans stayed on script, but even among them, a few appeared uneasy as the evidence refused to fade. When Cannon finally rose from her seat, she did so quickly, eyes downcast. The judge, who had entered with complete confidence, now appeared shaken and exposed, unable to defend her own decisions. Minutes after adjournment, the 7-minute exchange went viral. Crockett exposes Cannon shot to the top of global trending lists. The young woman's video spread rapidly across social media, garnering millions of views as both legal experts and ordinary viewers dissected the moment. Legal analysts on Twitter verified Crockett's claims against public court records and found them accurate. On CNN, longtime legal analyst Jeffrey Toobin appeared stunned. "In 4 decades of covering the courts," he said, "I've never seen a federal judge so thoroughly dismantled in a public forum." At Fox News, early coverage framed the exchange as a partisan spectacle. Yet even some conservative legal commentators hesitated to defend what had been revealed. Judge Cannon initially tried to weather the backlash. She issued a carefully phrased statement, dismissing the hearing as a political performance, insisting that her rulings were grounded strictly in law. Yet as independent reviews multiplied, and more rulings revealed a similar pattern, her defense grew harder to sustain. Within 3 months, she was quietly reassigned to a smaller civil caseload. Several of her disputed decisions were overturned on appeal, with higher courts citing clear legal errors, the formal expression of the very problem Jasmine Crockett had described in plain terms. Meanwhile, Crockett's national profile soared. Her alma mater established a scholarship in her honor. Invitations poured in from the American Bar Association, the National Association of Criminal Defense Lawyers, and law schools across the country. Her social media following expanded by millions. But more importantly, a criminal justice reform bill she had long supported, stalled in committee for months, suddenly gained dozens of new co-sponsors. Despite the attention, Crockett avoided self-promotion. In a 60 Minutes interview, she stated, "This was never about me and Judge Cannon. It was about our nation's promise, that justice is blind and the law applies equally to everyone. When judges forget that, it's our duty to remind them." Politically, the hearing reshaped expectations. Republicans who had planned to defend Cannon as a victim of partisan attacks began retreating to safer ground. Senators who once praised her judgment grew hesitant. The Federalist Society stopped inviting her to speak. Democrats, meanwhile, mobilized. They launched broader investigations into systemic bias and adopted Crockett's approach. Identify the patterns, prove the inconsistencies, and connect them to real-world consequences. Within 6 months, 3 other federal judges faced similar scrutiny. 2 chose to retire rather than face public hearings. Legal scholars would later describe the episode as a turning point. Harvard's Lawrence Tribe wrote that Representative Crockett had done more in one session to restore confidence in congressional oversight than years of previous attempts, proving that diligence and evidence could still hold power accountable. The most enduring image wasn't of Cannon's confident entrance or her subdued exit. It was the split screen during the final exchange, Crockett standing firm behind a table of documents and the judge silent, unable to answer whether she had applied the law equally. 6 months later, the teenager featured in the viral video received a full college scholarship from an anonymous donor. The note enclosed read, "Justice delayed is not always justice denied. Keep going." Many speculated about the sender, but the mystery only deepened the moment's meaning. Judge Cannon's public reputation never recovered. Historians would later note that her career didn't end with a formal reprimand, but with a question she couldn't answer. Crockett, in contrast, continued her work in Congress, now armed with national recognition and bipartisan respect from lawyers who, even if they disagreed with her politics, admired her precision and command of the facts. When a young law student asked what advice she'd give to those challenging authority, Crockett replied, "Do the homework. Know their record better than they do. Remember, facts are the great equalizer. Power can intimidate, but it can't defeat evidence." The reforms sparked by that hearing didn't stop there. New standards for judicial transparency emerged, including regular reporting on sentencing trends and audits to ensure consistency across similar cases. Analysts introduced the Thompson-Hartley test, named after the 2 cases Crockett compared, as a tool to assess whether the law was being applied equally. A year later, the American Bar Association honored Crockett with its Champion of Justice Award, which she dedicated to public defenders and defendants who had been denied equal treatment. The standing ovation lasted 5 minutes. A prominent legal blog summarized the moment. Crockett didn't just win a viral exchange, she raised the standard for judicial accountability. Federal judges now understood that their rulings were being tracked, and that patterns, whether fair or flawed, would be examined in time. Judge Cannon mentioned the hearing only briefly in her memoir. "I was unprepared for the depth of analysis Representative Crockett brought forward. In hindsight, I should have been more aware of how my rulings appeared collectively. Every judge should learn from that experience." It was the closest she ever came to an admission. The case files Congresswoman Crockett had referenced were soon digitized and made public, quickly becoming a vital resource for researchers studying bias in judicial outcomes. The Brennan Center for Justice went further, creating the Crockett database to monitor national trends in court rulings. Within a year, analysts detected concerning patterns across multiple courts, leading to targeted reforms that ultimately impacted millions of lives. But the most lasting change occurred within aspiring lawyers themselves, inspired by the image of a first-term representative methodically dismantling a deeply entrenched narrative using only documented evidence. Her structured, disciplined approach reshaped how a generation viewed advocacy. Law schools across the country saw a surge in applications from underrepresented communities, with many citing that hearing as their motivation. In the same courthouse where Judge Cannon once presided, public defenders reported noticeable shifts, fairer plea deals, more thoughtful explanations during sentencing, and an emerging awareness that every decision could one day be examined as part of a broader pattern. The possibility of becoming the next judge publicly exposed for bias became a strong deterrent. 3 years later, Congress passed the Equal Justice Act, requiring yearly reviews of sentencing disparities and creating a civilian oversight board for federal courts, informally known as Crockett's Law. At the bill's signing, Jasmine Crockett stood behind the president, holding the same manila folder she had carried into that hearing room. That simple, overstuffed folder became a national symbol of one principle. Power is not proof. Documentation is. Ms. Thompson, the mother whose case had moved the hearing room to silence, was later released on appeal, her sentence reduced to time served. Crockett met her outside the courthouse, and the photo of their embrace, surrounded by Thompson's children, became one of the most shared images of the year. The caption, repeated across social media, echoed her daughter's words: "Justice delayed, but finally delivered." Across the country, law schools began requiring students to watch the hearing's key moments. The closing question, "Can you honestly say you've applied the law equally?" became known simply as the question. Professors used it as a benchmark for integrity, challenging students to imagine defending their own records under the same scrutiny. In time, Judge Cannon stepped down from the bench, moving into private practice to advise corporations on compliance and accountability. She never gave interviews about the hearing, but colleagues noted she kept a photo on her desk, not of herself, but of Crockett at the microphone, a silent reminder of how quickly power can fade under the light of truth. The influence of that moment continued to spread. Courts nationwide adopted data dashboards to monitor sentencing disparities. Judicial confirmation hearings began incorporating data-driven questioning inspired by Crockett's methods. Legal circles even coined a new expression, pulling a Crockett, meaning to reveal contradictions through meticulous use of a subject's own record and words. 5 years after that defining hearing, Jasmine Crockett raised her right hand and was sworn in as a federal judge, nominated by a president who praised her unwavering commitment to equal justice and confirmed with bipartisan support. During her investiture, she vowed to remember that justice is not about the judge, but the people before the bench. Commentators noted the poetic symmetry. The woman who once asked the question would now have to live by it. At a law school commencement shortly after, the young woman whose viral video had once moved the nation walked the stage to receive her law degree. The keynote speaker was Judge Jasmine Crockett. Years ago, she told the graduates, a courageous teenager reminded America that behind every case file and caption stands a human being. Justice is not theoretical, it's personal, and it must be equal. The audience rose in a standing ovation as that same young woman announced her plans to serve as a public defender. Later, a documentary titled The Question, How Jasmine Crockett Changed American Justice, premiered to widespread acclaim, winning multiple Emmy Awards. It featured legal scholars, defendants impacted by unjust rulings, and even judges who admitted that the hearing made them reconsider their own decisions. A former clerk for Judge Cannon, speaking anonymously, summarized it best. That day changed all of us. We each had to ask ourselves, could we answer the question? The impact of that single question extended far beyond U.S. borders. The Inter-American Commission on Human Rights cited the hearing in a landmark report on accountability. The European Union invited Congresswoman Jasmine Crockett to speak about legislative oversight. Law schools in Tokyo and London created case studies around her approach. A decade later, the Harvard Law Review ranked the confrontation among the most significant congressional hearings in American history, alongside the Army McCarthy and Watergate hearings. The editors noted that while those sessions exposed corruption or abuse, Crockett's revealed something deeper, a quiet, systemic imbalance in justice that denied true equality and inspired reforms that lasted. On the hearing's 10th anniversary, NPR aired a retrospective highlighting lives changed by the resulting reforms. A small business owner credited fairer sentencing guidelines for keeping him out of prison. A corporate executive described being held accountable under standards that ignored his wealth and influence. Public defenders spoke of judges who became more transparent and consistent in their rulings. The most memorable interview came from Ms. Thompson's younger son, the boy who once cried every night. Now a criminal justice major, he said, "Representative Crockett didn't just expose one judge. She showed us someone was watching. She gave us hope the system could change, and it did." That same day, Crockett released her memoir, The Question, pledging all proceeds to fund legal aid. "I walked into that room with a folder and a question," she wrote. "I walked out with a movement. But the real heroes were the families who lived under unequal justice and still found the courage to speak." For the first time, Judge Aileen Cannon, now fully retired, issued a short statement acknowledging what many had long believed, that the hearing marked a turning point for American justice. She described accountability as responsibility, not persecution. Analysts noted it was the closest she had come to admitting the legitimacy of what the hearing revealed. Over time, the standard Crockett championed took root. Bias, once hidden in individual rulings, became visible when analyzed across entire dockets. Her question, "Can you honestly say you've applied the law equally?" evolved from a rhetorical challenge to a measurable expectation supported by data and oversight. The teenager at the center of the original case became a public defender, later a reform-driven prosecutor, and eventually a judge. When she took her oath, it was Judge Jasmine Crockett who administered it, closing the circle. "My mother went to prison because a judge forgot that justice should be blind," the new judge said. "Today I swear never to forget." Historians later identified that hearing as the moment American justice began to shift back toward its ideals, not perfectly, not fully, but undeniably. It all began with a first-term Congresswoman from Texas who did her research, brought her evidence, and asked a question no federal judge could answer. The folder Crockett carried that day now rests in the Smithsonian, part of an exhibit titled "Moments That Changed the Nation." Next to it lies the transcript, open to the final exchange. Visitors often stand silently, reflecting on the simplicity of the question and the weight of the pause that followed. A small plaque reads, "On this day, Representative Jasmine Crockett reminded America that truth, backed by evidence, can still challenge privilege and prevail. Justice is not about who you are, but about what is right. One prepared voice can make the system bend. Every year, first-year law students watch the footage, the judge's confidence fading, the Congresswoman's calm persistence holding firm, the instant when a question became a reckoning. Professors tell them the goal isn't to seek drama, but to build a record so solid it speaks for itself, methodical, factual, and fearless." The hearing room later earned an informal title, the Crockett Chamber. A plaque by the entrance bears her words, "Justice isn't about the judge, it's about the people who stand before us." Everyone who enters to testify or to question sees that reminder first. Authority is temporary, but accountability endures. In legal textbooks, Judge Aileen Cannon's name now appears as a warning, an example of how patterns, once exposed, can outweigh any single ruling. In those same pages, Jasmine Crockett stands as the representative who redefined how Congress can hold the judiciary to account, not with outrage, but with evidence. Her legacy proved that oversight isn't theater. It's the stewardship of equal justice under law. If this story resonated with you, courage versus privilege, proof against power, share it with someone who needs to remember that systems can change. Leave a comment about a time you saw truth prevail, or when you spoke up despite the risk. Justice isn't a gift from the powerful. It's a right we protect every day. And as that hearing reminded us, sometimes all it takes is one question, asked at the right moment with the evidence to sustain it.